Did it appear unreasonable to you as an officer that this driver of this car, Daunte Wright, with this warrant, would do what he did? Did it seem unreasonable to you?
Yes.
So after the second, I'm going to tase you, and that's the one you heard. After you heard that one, did the Daunte Wright stop at any time and say, okay, I'm done, give up?
No.
And at that point in time, was that when you went into the vehicle to grab that shifter?
It was probably a little bit before that.
Okay. And you're in there and you were struggling with him with your strength, right?
Yes.
To you, it was an exigent circumstance, an emergency, correct?
Yes.
And you were trying to get a hold of the shifter to stop him from grabbing that, correct?
Yes.
And you also tried to get a hold of the key with the other hand, correct?
Yes.
And you were in that vehicle and your body was lying over the young lady in there, correct?
Yes.
And one reason your body was lying over her was to keep her from sitting there, right? So she wouldn't get involved.
Yes.
Her statement?
Yes.
And then you weren't having any success in calming him down either, were you? He was still fighting and struggling, correct?
Yes.
And then you heard taser, 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 and that would be approximately 3 seconds after you heard Officer Potter say, I'm going to tase you. There was a time period between when she said that and when she said taser, 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 correct?
Yes.
During that time period, did Daunte Wright at any time show any sign of stopping, giving up, saying, okay, I'm done?
No.
And then after, when the taser, taser, taser was said, approximately a second later, you heard the shot and you thought it might be a taser, might be, you didn't know. It was a loud noise, correct?
Yes.
She said, oh my God, I'm going to go to prison. Do you remember her saying that?
Yes.
And Lucky said, according to the video, no, you're not. No, you're not. Kimberly says again, oh my God. Lucky says again, no, you're not. You remember that?
I don't.
All right. Then you said, Kim, the guy that was trying to take off with me in the car. You agree you said that, right?
Yes.
And if he had taken off with you in that car halfway, what would have happened to you? What would you think would be the worst that would happen?
Probably dragged.
Dragged and what?
Injured.
Seriously injured, maybe even dead, right?
Yes.
And if that were the case, would an officer in your position, with Officer Potter trying to stop him from resisting with you and resisting Lucky, would it be fair for that officer to use a firearm to stop him?
By state statute, yes.
By state statute.
Yes.
There's a statute that says to avoid death or grave bodily harm, you have a right to use deadly force, correct?
Yes.
And you're aware of that statute.
Yes.
So basically, based on these videos and the conduct of Daunte Wright, as far as you're concerned, and you were there, Kimberly Potter would have had a right to use a firearm, right?
Yes.
That's a prosecution witness. Prosecution witness. And just to compare, if you look back to the last trial we covered in this courtroom, Derek Chauvin, there were no officers getting up on the witness stand saying what Derek Chauvin did was okay, was justified. But now you've got one who was at the scene, number one, and number two is a prosecution witness. Let's bring in Court TV legal correspondent Julia Janae joining us live tonight from Minneapolis, Minnesota. Julia, I know at this moment you alerted all us as this was happening. I was watching this happen today. Big difference in this case versus Derek Chauvin in the way it is playing out in terms of the actions of the officer, because Derek Chauvin, there was nobody other than the paid expert who came in and said what he did was okay. So this is a major, major difference.
It's a major difference in the way these officers are testifying about Kim Potter. You're right. During the Derek Chauvin trial, there were many officers who came in who were not experts, but were talking about the things that we're hearing these officers talk about: the scene, the investigation, how things moved. But a lot of them, through their lay testimony, their fact testimony, they talked about their training. And many of them at the end said it was not okay, or they didn't know anything in their training that said that it was okay to keep a knee on someone's neck for 8 minutes, for that long of a time. So it wasn't an expert opinion, but they did say that it does not seem that this was condoned. That's not what we've heard from this line of officers who have come into the courtroom, and that just really was highlighted today with Major Johnson. He was a sergeant at the time. He's been promoted. He's with a different department now. So really difficult for the state to then try and rehabilitate him after this happened, because they had spent the extent of the direct examination really letting this jury know his credentials, how respectable he is. And he was the supervisor of Kim Potter at the time. Let's take a listen to that attempt by the prosecution, Matthew Frank, to try and rehabilitate this witness after that really fiery cross-examination.
Is there a policy in Brooklyn Center about that?
Yes.
And is there also a policy about using a taser on people who are operating motor vehicles?
Judge, same objection. I didn't mention it at all.
All right, I'm going to let you answer.
Somebody that's operating a vehicle, yes.
And so the reason for that is what?
If they're moving, driving a vehicle and you incapacitate them, it could cause an accident.
That's just what Mr. Gray was getting at, correct?
Yes.
I have nothing further, Your Honor.
At the time that Daunte Wright was shot, was that vehicle moving?
No.
That's all I have.
Anything further?
And that redirect and recross went on like that for several times. Frank there was pointing out a policy that exists with the Brooklyn Center Police Department on taser use. And it says that there are particular instances where a taser use should be avoided. One of those is when the car is moving, when someone is operating a vehicle, or if they are doing something that is inherently dangerous. So that is something that he was trying to get this witness to talk about, but ultimately it still seemed at the end of this testimony this witness favored the defense more than the prosecution.
And I look at this case, it's more about, it's not so much arguing about what the facts are, it's about what it all means. It's like a battle of opinions versus fact, and this officer gave his opinion on what happened there. But let's get back to the one fact that may be crucial for prosecutors, and that's the movement of the car. Despite the fact that former Sergeant, now Major Johnson, testified that the car was not moving, the state is still going to argue that Daunte Wright had control of the car when he was tased, or attempted to be tased and was actually shot. I'm making the same mistake that the prosecutor made today. He wasn't tased. The attempted tasing, which was an actual shooting.
Exactly. That's something that is disputed and hard for us to nail down. We've had different people come in and say different things. We had the girlfriend, Elena Albrecht Payton, yesterday testifying that she didn't ever see Daunte Wright's hands on the steering wheel, but then when pressed on it, it seemed that she didn't really remember. She said it happened so fast. When you see the video, the car does look like it first is in a lane and then that it veers off, of course, eventually crashing into another vehicle. And today you heard Officer Johnson, Major Johnson rather, saying that he was trying to put the gear in park and take the keys out of the car. He was never able to get to the keys, but he wasn't sure if the car was not in park before or if he's the one who put it in park. So really unclear the status of this car and whether Daunte Wright would have been able to drive off and drag the officer on purpose, or if the tasing is what, or the attempted tasing and the actual shooting is what then caused him to drive off.
This is really turning out to be a little bit different than I thought it was going to be. Julie Janae, great work. We'll talk more. Let's bring the think tank right now. Joining us tonight in New York, New York, former senior homicide prosecutor Bernarda Villalona. In Minneapolis, Minnesota, criminal defense attorney Joe Tamburino. And in San Diego, California, criminal defense attorney, former prosecutor Brian Watkins. You can contact him at brianwatkinslaw.com. I'm going to start with Joe Tamburino. He's in Minneapolis. Joe, let me ask you, is this what the defense is? It has to be a justified shooting because there's no accidental defense. What is the defense right now? Because my mind is very confused tonight because I thought this was going to be about, well, it's an innocent accident. It doesn't rise to the level of recklessness that is necessary for it to be a crime. Today, what I'm hearing from the prosecution witness is that this was a justified shooting. So even though she didn't intend the shooting, it was justified.
Thanks for having me on, Benny. No, what this officer gave the defense is a complete gift. It's now a secondary defense. The first defense is still, this was an accident. She meant to grab the taser, but she grabbed the gun. And she did not act in conscious disregard to the safety of others, which is the standard of recklessness. But this major today gave the defense yet a secondary argument, which is, look, even if she did want to grab the gun, she was justified in this situation. It was a complete gift to the defense. And quite frankly, the prosecutor never tried to stop it, never made an objection, and obviously didn't prepare his own witness because he should have known that his main cop, this guy was the commander on the scene. He was gathering evidence. He was separating people. How do you not know what he's going to say?
Bernarda Villalona, put us in the shoes of the prosecutor here. I mean, the prosecutor can't hide evidence. You can't withhold evidence. It is what it is. You can't tell the sergeant, now Major Johnson, what to say, but maybe you should be prepared for it. I don't know.
Exactly. So I either think, one, the prosecutor wasn't prepared for that question answer, or two, they were aware that that would be his answer, but didn't have somewhere of being able to counteract that. Because you can't act and be like, oh, I'm going to change his mind, because the law is the law. So that sergeant wasn't going to change his mind. The problem I see here is that the prosecution's own witness may have created reasonable doubt in this case.
Brian Watkins, I never know what you're going to say. That's sometimes I think about, I think Bernard is going to say this, or some of the other guests. You are the most unpredictable of all guests, so I'm just going to leave it open-ended. Your reaction to this testimony today?
I got to agree with Bernardo on this one. I don't know if the prosecution knew that's what he was going to say and said, well, let's go ahead and get in front of this and let's put it out there, because you know how terrible it would have been if the defense calls the main cop on the scene to testify like he did that supports the defendant. That's even worse. So I don't know. I mean, the way the prosecution put that on, I thought they were like throwing it. I want to see where they bet their money, because you got a problem when you put on a cop who's friends with the cop that's being prosecuted. I don't know how you would expect damaging testimony. Yes, it happened in Derek Chauvin's case, but that's rare. And in a situation like this, I don't see these cops trying to slay and persecute their fellow cop. So I don't know what the prosecution was expecting. And they got a hell of a surprise, as did I.
Yeah. Joe Tamburino, what are your thoughts if she intended to pull out the weapon? I mean, it gives you just the one defense, but, this is where you practice. How would that go over if we were talking about a case where this was an intentional, deadly shooting?
It would be a much more difficult case, and here's why. You would have to show, and
Difficult
the Minnesota
for who?
statute is for the defense, because you'd have to show under Minnesota law 609.066 that the surrounding circumstances would clearly show that an officer, either herself or a fellow officer, was about to receive great bodily harm or death. And quite frankly, that's a little unclear, because as we know, that car really wasn't moving at the beginning, and Major Johnson extricated himself from the car only when he heard the word taser. So it would be more difficult had she said her defense is, I intentionally fired the weapon. But they don't even have to go there, because as you can see in the video you're playing right now, she said, oh my God, I shot him. I didn't mean to shoot him. So she's got a very good accident defense, but it also helps to have this secondary, what the officer gave today.
Bernardo, every time I talk about prosecutors, I talk about, what their role is in a courtroom, which is to seek the truth. So if you're the lead officer there, this is what he believes, this is what he says. I almost feel like, despite the fact that it can harm your case, you have an obligation
Yes.
to put him out there and let him say what he's going to say.
Absolutely, 100%, especially when you're talking about a law enforcement officer. You can't hide the facts. You can't hide the truth. You have a different role from the defense attorney when you are a prosecutor. You have to lay out the facts the way that they are. And I'm sure, for example, if it was something that was said in private, even, that would be Brady information where the prosecutor would have to turn that over to the defense, just to go to show you the high standard that we have for prosecutors. This unfortunately was a bad fact for the prosecution, and we'll just have to see how bad was it, how it'll be argued in closing arguments. But I think to end on a Friday where you have a weekend, 2 days, and to end this way is a problem for the prosecutor. But I think that the prosecutor can play it a different way in the sense of with the taser and the accident that we saw, that is the exact reason why you don't use your taser when a person's in a vehicle, in a moving vehicle.
All right. Wow. Think Tank's with us the whole hour. Let's bring back in Julia Janae, Court TV legal correspondent in Minneapolis. Big week here. What's in store for Monday?
Well, Vinny, today the jury went home early because of a snowstorm that is happening outside. I know we have a live look at what the Hennepin County Government Center looks like right now. So barring any weather conditions that will be stopping things over the weekend into Monday, these jurors will come back and hear from the medical examiner who was on deck today to testify, but that didn't happen because of that early end. Autopsy photos will be shown to them of Daunte Wright. This is over the defense objections, but it'll be limited. The state won't get to show all the images they want to show because the judge said she doesn't want the jury to make any decision based on sympathy, only on the facts and evidence.
All right. And I expect everyone to be there. I mean, anything less than 2 feet in Minneapolis is just a dusting of snow anyway. Julia Janae, rest up this weekend. Stay warm. We'll see you on Monday.